this computer. We're live. So allow me to go ahead and introduce our speaker for tonight, Mr. Denis Kenny. Denis is a founding partner with Scherer Smith Kenny LLP. I hope I'm pronouncing all that right. He's an experienced civil litigator specializing in employment litigation and counseling for employers and employees. Before his current firm, Denis served 3 years as a Deputy Attorney General in the Employment Rights and Administration Division of the California Attorney General's Office. He brings 20 years of experience as a knowledge expert on independent contractors and 1099 compliance-related issues. So without further ado, ladies and gentlemen, Denis Kenny.
Thanks so much, Rachel, for your wonderful introduction. It's a pleasure to be with you all tonight. I wanted to start by saying that looking at my notes, I spoke with Joe Devney back in January, believe it or not. Hi, Joe. And Joe had given me some really good thoughts and topics about your group a little bit. I thought it'd be useful to see if this is still relevant. I suspect it is, but there's been many developments in our independent contractor compliance law, even since January 31, 2020. But he mentioned about your chapter that many of you work on a part-time contract basis. You're really interested in how AB5 might affect you, as a group and individually. As the quote I had, it seems a law wasn't written with you all in mind. And that's pretty good, fair takeaway. I think a lot of people feel that way. What sorts of things can you, as service providers in the industry, do to make sure that you comply with the law and alleviate your clients' concerns, primarily, I would suspect? Provide more insight into what is going on in Sacramento on this issue, and that you held your meetings in the Oakland Hills. So in that instance, at least we're holding meetings on Zoom right now. But I think Joe probably accurately described a lot of things that are going through your minds and have been going through your minds for the past several months. The key thing about independent contractor compliance, I've been doing that as a part of my employment law practice since 1999. I was with the State Attorney General's office per the bio before that, doing exclusively defending employment lawsuits and bought by employees of the state of California. Did appellate work. I did a lot of trial work, volunteered for everything. And then I decided to do a more entrepreneurial practice where I have my own firm and now have 10 other folks working with myself and 2 partners. And I work primarily on the management side, supporting employers trying to do the right thing, and when things aren't done right, defending them in litigation. So that entails doing a lot of employment contracts, commission plans, and also just making sure that they're classifying their workers correctly. And hopefully they do those sorts of things, those vetting and due diligence before they hire and pay those workers. But oftentimes it's the latter, not the former. But I also do a handful of employee side cases, and actually it allows me to be, in my opinion, quite objective, and most of my clients feel that to be the case. And I often can say, well, I'd rather have their case than yours, or vice versa, and here's why. And I give them case studies. But I have a case right now, and it's addressing essentially 3 different legal constructs of independent contractor law, because it spans the course of essentially June 2015 to present. And I'll touch upon some of those things, but I have a lot of kind of like real-time knowledge about what's going on. And I can tell you this much: courts are grappling with the same questions and uncertainty that all of you are dealing with. This AB5 test was designed to be really simple, but in practice, California's version is far from that. And it's a blessing in disguise for lawyers, unfortunately. It's not so much for, my clients on either side of the fence. But to give you an analogy, the state of Massachusetts has had the ABC test, which is what AB5 codified January 1, 2020. The state of Massachusetts has had that test, which we copied from them, since 2004. Suffice to say, Massachusetts is still on the map. Businesses did not depart, workers did not depart in mass, and they're doing okay. But the fear mongering is, I think, at play, and partially was how all these exceptions were built into AB5, which is why AB5, although it has an ABC test, which we'll talk about, is far from the really simple, straightforward version that in comparison, Massachusetts has. So why is there so much confusion? Why is it that Joe asked, a lot of us think that this law wasn't written for you all in mind? Because, originally it was really designed, and it got a lot of traction because it was addressing these, gig workers, the Grubhub people, the Ubers, the Lyfts, sort of the concept of these folks that are being victimized by the companies that are being able to pay them, really low rates. Essentially, they're getting a low cut of, what is ultimately a below market rate in the context of Uber and Lyft. Why are they so great? Well, in part, you can actually get, a ride, whereas in the old days, if you lived out in the suburbs like me in Walnut Creek, you could never get a cab. Now you can call an Uber or a Lyft and they'll actually come out to my place and take me to the airport. So how are they able to do that? Well, they're able to undercut, what are actual costs of doing business. Most would say costs of, doing business the right way by classifying folks as employees and having to pay those attendant benefits, wages, etc. So, what is the uncertainty? Well, the law was designed to sort of get hype and interest for a lot of folks that look at it as paternalistic, protecting workers from being victimized. But in the end result, it was kind of a catch-22 and a gotcha because it applies to all industries. So then interest groups paid a lot of money to lobbyists and such to try to build in exemptions and exceptions. And that was the only way it got signed. I mean, it was being changed on the, the governor's desk up to the last minute. And by the way, it's still being changed. And then there's another, ballot initiative coming up, which is sponsored primarily by Uber and Lyft, seeking to have ride-sharing applications, really theirs, exempted from the law. So there's all kinds of sort of confusion that abounded, not to mention a lot of the press, be it, the small and very short pieces they might show you on the local news or the articles in papers have just gotten it flat wrong. Because even though you can find in this instance exceptions, certain occupations, exemptions like the business to business and professional services exemption, the 35 publication per client that you probably all are aware of, all those things, all that means if you fit into that box, it just means the ABC test doesn't apply to you. You still have to deal with what has been on the books for years, which is, the law in California of a multi-factor test to determine whether people are viably independent contractors or workers. And the most critical piece of this puzzle, no matter what you can say about AB5, is there is a presumption that every worker in California is an employee. And it's up to the hiring party, your clients, to prove otherwise. So you see the stakes are really stacked up against the businesses that want to hire, you all or others who really want to stay as independent contractors. And, the stakes are huge. I focus on just the penalty element, and there's a lot of different percentages and the such about for every dollar, you'd have to pay to an independent contractor. If you get it wrong as a hiring party, you're going to end up having to pay, 70 to 75 cents on top of that for every dollar. So you multiply that. Say you paid, you got paid, or your, a hiring company paid a contractor $100,000 in 1 year, and they got found to be misclassified by the IRS or the EDD, and they have a memorandum of understanding, and it results in audits. In theory, you could have penalties under California law, for $70,000 to $75,000 for that one employee for that 1 year. That's an example of just kind of a heightened awareness and exposure that, really is now front and center for folks, which is why, from either the hiring standpoint or the people providing services, they're going to be having to deal with these issues. And these issues are, a lot of workers really want to maintain their business, their, ability to work for many different clients, whether it be technical writing or otherwise, and reap the benefits from a tax standpoint of writing off your office expenses, writing off the mileage, writing off your computer and cell phone and such. So there's some serious benefits to that. But unfortunately, it's the downside exposure and what happens if things go wrong that are really making people who are thinking about these hiring decisions think twice. So you'll have, I had one industry, a fair number of people making inquiries about it from both the worker and the hiring party side, dealing with professional coaches. These folks who work with executive level employees of, Fortune 500 companies. And they'll often be working with kind of like an intermediary, a service provider, that affiliates a bunch of this talent, because professional coaches, in the corporate coaching world are hard to find. So there'll be a base of operations, and then, a client, whether it's like a Genentech or a Visa, can pick, from this talent pool. And the result, though, in that instance, is the stakes were so high from the companies that were, having the coaching done for their employees. They said, what, we can't maintain this independent contractor model. It's not going to work for us, because, we'll be caught in the middle of a lawsuit if you don't W-2 these people. It's flat joint employment law. And that comes up in a variety of contexts, oftentimes in the staffing world. I see Andrew Davis nodding his head. I think I understand you've had a staffing business in this arena. And a couple of the companies I work with, ClearPath Workforce Management and Populous Group, they provide contingent staffing, some of it employer of record and otherwise. So that's at a high level. Those are kind of the competing interests that are at play. And I say the more things change, the more things stay the same a lot, because truly what I'm talking about now is not that much different than what I was talking about and learning about in 1999. And have been talking about since. It's just a different type of test that is now a bit more simplistic, and the stakes are a lot higher. And the publicity is much higher. That is one thing that's for sure. But I will tell you that the government has always had in its budget, and primarily in the Democratic administration budget, enforcement in the audit departments for the IRS under the federal side, and then the state for the EDD, to crack down on folks misclassifying, because there's a payroll tax gap. The bottom line is there's this underbelly of what the government would say of underfunding of taxes. So that was a real big impetus at the end of the day that isn't really highlighted on. It's been the case for years, and it's been a part of GAO budgets for years. So what are we talking about? Number one is, it doesn't matter the label or the moniker you put on yourself or someone puts on you. Freelancer, gig worker, on-demand worker, vendor, subcontractor, you hear all those terms. At the end of the day, you have to determine, is that end worker an employee or an independent contractor, regardless of the label. So sometimes you'll have multi-layers of intermediaries, whether it's a staffing company that handles just payroll, whether it's an on-demand company, they call it the human cloud, talent cloud, like Upwork or Talent Rover or MBO Partners in different various fields and industries. It's essentially just an online intermediary, but it's a company who's, like I say, pooling a bunch of talent that may be hard to find in one place, where prospective hiring parties can choose from that talent. But at the end of the day, who's doing the work and for whom are they doing that work for is what you're going to get down to. And so what does the ABC test do? It's a really simple test. In theory, it's fairly simple under Massachusetts version, which we copied. It just is made more difficult by these exceptions. But remember, it's the presumption of the hiring party. I say hiring party, not the business, because it could just be you or me working, living in our home, hiring a nanny or something. By the way, you still have to apply the same test. So hiring party. The hiring party has to prove that the worker is free from control and direction of that party in connection to the performance of that work, both under the contract and in the actual performance. And I'll get to that in a minute. In fact, so it doesn't matter, like, oh, you have this great bells and whistles contract. It just speaks all of independent contractor. But in fact, what they do on a day-to-day basis, that worker has nothing whatsoever to do with the contract. Or you could have the alternative, This thing, you have to have both just to meet A. And I'll go to C. C is that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So in other words, if as a technical writer, that's your trade, you're working for a bunch of other people, and you're being hired by this prospective, hiring party. Let's say it's Scherer Smith Kenny law firm to write, some kind of content relating to, our incredible HTML website that we just developed. Right, that's not true, but it's possible. That's in the same nature of the work you perform. Unlike if you have an established business and you're, let's say you're a general contractor and you're being hired out to do technical writing. It's just like you're using this base business. It has nothing whatsoever to do with your actual, business and service that you're providing in this particular instance. That won't be good. But as you can probably imagine, A and C, in a lot of circumstances, where workers have sort of done business as independent contractors and hiring parties have, sort of allowed them to do it for some period of time in a multi-client manner, are fairly, not easily met, but they're fairly met on a wider scale, certainly, than what is C. B. And B is what we call the killer bee. It's a conundrum because in our, world, the fact that the hiring party has to prove that the worker performs work that is outside the usual course of the hiring entity's business. And you probably know enough about what you've seen in the press and such. This is really a difficult one to meet. And it's what we call the killer bee because it's the downfall of most of these classification scenarios. And unfortunately, the courts that have given examples have been pretty, simple in what they've done. So they said, for example, like, well, let's say a cake, a baker, a bakery hires a cake decorator. Well, obviously, that would be something that's in the course of their business. You don't have a cake without decorations or, frosting and such. So the court said, well, we just want to make sure, since you wouldn't possibly know this without thinking about it, we'll give you that example. Whereas the one they give you for sort of what would be a viable, outside the normal course of business would be something like a business, a law firm like me, hiring a plumber to fix a leak in the bathroom in our office. Well, obviously, we are not in the business of plumbing. Obviously we need a bathroom to do our business, but luckily the court has sort of identified, that's not what we mean by this test. So you see, under the true ABC test and the presumption of employment, it's pretty darn simple that, most companies would have a really hard time of justifying the classification of a lot of the people they've been traditionally using and classifying as independent contractors. I had one example of kind of like the gray matter, where there is still going to be close calls even under this test, where a company does branding. They'll come up with catchphrases for companies. For example, my company's catchphrase is the strength of partnership, because we have a strong partnership as a law firm, but we also view our clients as effective partners, and we're in a joint venture in that. Like, hopefully it's good, but I didn't use my client to do this, but that's an example. They'll come up with catchphrases, they'll come up with logos, they'll come up with all that sort of thing. And then sometimes they'll do, video pieces. And these are really professionally done, for Fortune 1000 companies, where they'll do, website pieces. Maybe they'll post it on social media, et cetera. But so my client doesn't have in-house people to do that. It's basically video production. So they've used a cadre of trusted outside providers, but these are pretty small providers. It's like one, maybe 3 people shops, and they'll use them probably on maybe 40 to 50% of their engagements. So that's a close call right there, right? That's one where I said, you'd have to really develop a good track record, and I call it defense file, for why you made the decision to maintain what they're doing as independent contractors. As it turns out, under the recent amendment to AB 5, that advice was pretty good, because AB 5, this amendment came up in April, May, talked about musicians and some film production as essentially being another sort of exempt category under certain circumstances. So it goes back to, the old test, Borello. But the idea being, in theory, this is, a really difficult test to meet. And it's difficult for everybody involved, because it leads to, really kind of a recognition that in a variety of different industries, I would say technical writers being one, the majority of folks who do the services and the writing, want to stay independent. They don't want the entanglements of, being tied to, mostly you'd be a part-time employee of perhaps, many different employers. So sometimes that the idealistic goals and truly good goals and aims result in practice in a really difficult application of how it translates to the real world. But what does if that simple ABC test mean in practice with all these exemptions and exceptions? I mean, the goal of just getting an exception, fitting into that box, is you just go back to what is the old test. And I told you about this case I have right now where, we have essentially our feet in three tests. We, part of the period we say, they're sales representatives for medical device company, the ABC test applies without question. And it's if that test applies, it's a no-brainer. These sales reps would be misclassified and they should be employees. Part of that test, though, does deal with before AB5 and before dynamics. So there's an actual, application of Borello. And then there's another argument for some of these sales representatives who had corporations and LLCs that in theory they could meet this business to business exemption. So it's a mess. I mean, and believe it, think about this. You have 25 pages in this particular legal brief that you write to the court, and you have to address, just as part of this, what should be, a fairly straightforward analysis, 3 different tests. And as you probably are aware, the business to business exception, again, which would just get you outside of the ABC test and into this multi-factor Borello test, it has 12 elements to get, that has to be met just to get to the, back to sort of the playing field of, okay, now we have to go look at the other, existing multi-factor test, which is 11 elements. So, and a lot of people are writing about this as being kind of the solution to everything. And that is, okay, if you don't already have a corporation or LLC and you're, someone who wants to provide services to clients and keep doing that and reap the benefits of tax write-offs and such, all you need to do is set up a corporation, or all you need to do is set up a limited liability company, and that solves the problem. And that's a tiny, tiny bit of accuracy. It's a good idea, certainly. Andrew does the same sort of checklist when you're looking at independent contractor compliance. You want to look at, just sort of big picture vetting issues. Like, does this actually feel like a real business that we're talking about? Or is this truly just Denis Kenny who, made a company called DSK Incorporated and is working, essentially 99% for one particular client and is getting paid by the hour? And that's where in the old days, maybe 10 years ago, you could kind of pull the wool over a lot of auditors' eyes just by having workers, have a business established, and you'd have a defense file. So they have, if it's a corporation, they have articles of incorporation and bylaws. They, make sure they register with the Secretary of State and stay up to date on that. And so an auditor would look at the Secretary of State website. They see, oh, great, it's the DSK Incorporated. It's a business. It has an agent for service of process. They see a link there to Articles of Incorporation. They ask DSK Incorporated or the party that hired me, like, hey, is there a list of representative clients that this provider is servicing aside from just yours? And there's a defense file that shows that I provided a CV with a list of representative clients. Is there a proof of insurances, general liability and workers' compensation for one? again, you would have that in the file. So those are all just the minimum, I call them barriers to entry of what you would want to have just to sort of be in a position of having someone kick the tires a little more to possibly allow this independent contractor engagement to either continue as is, to start anew, or sort of figure out if additional information is needed. So the Borello test, what I've been talking about, the multi-factor test, which is just what happens if you get out, if you find yourself an exception or exemption to that ABC test. Again, this is just the laws as it has been in California for the past 15 plus years, is you got to go through 11 factors. And again, it's still a presumption. And I'll just go through them pretty quickly, but they're the sorts of things I just sort of gave you examples of, which is what, you want to already have thought through. But, and you'll see some of them are a little bit familiar from what I just told you about ABC tests. So the person performing the work is engaged in a occupation or business that is distinct from the company that's hiring them. Remember, that's part B. It's not an integral part of the business that is hiring them. Another word for that in the staffing world has been staff augmentation. If the company that's seeking to bring someone on as an independent contractor has workers that are performing the same or similar work as employees, that's a pretty bad fact. That's one of the first things an auditor will ask, because that's indicative of, well, how could you possibly say that the work isn't integral to the business of the company that's hiring you if they have employees doing it? So you're almost like, oh, you don't even have to go to factors 2 through 10 or 11 because you can't even meet one. So other factors, whether the work is part of the company's regular business, sort of says the same thing, but that has to do with the company that's the service provider. Whether the company or the worker supplies the equipment, tools, and the place for the person doing the work. Again, in our world of remote work, where a lot, it's becoming almost, even without COVID, the rule, the rule, not the exception, and it's probably going to be even more so. This is going to be less of an issue, and it doesn't have, none of these factors all have to be met to actually pass or fail this test. It's in the mix. But the other is the worker's financial investment in the equipment or materials required to perform the work. This was kind of geared towards more traditional brick and mortar work, where you might have really costly computers or costly software programs like AutoCAD in the old days for architecture and such, things that were all sort of invested in the company, and that would be indicative of, hey, I'm not just doing this fly by night. This shows me why, these representative clients are real, and I'm not dependent on one, hiring company, the one you're talking about. Skill required in the particular occupation. Again, this is sort of one of those factors that's almost in the paternalistic way of looking at it, but the concept in the case that developed these factors entailed agricultural pickers, agricultural field workers. So that's why this was particularly relevant. It's not always relevant though, but it is indicative of like, well, is this a unique skill that the worker's doing, like technical writing, or do you need to be trained by the hiring company? In that instance, workers in the field, they may not need training anyway, but they would be told when to do things, how to do things, and where to do things. The kind of occupation with reference to whether work in that area is typically done at the company's direction or by a specialist without supervision. Again, in sort of the journalistic, world where you're creating something unique, potentially that's copyrightable, and this would weigh more in favor of, independent contractor because it's a lack of supervision. Opportunity of the worker for profit or loss. This has to do really with how you're paid. The more you're paid like a traditional employee, the worse this would be, from the standpoint of trying to justify independent contractor classification. So, payment by the hour, it's not the death knell of an independent contractor test, but it's not a good factor. Better factor is being paid by deliverable, paid by, completion of the publication or something. Or sometimes in sales world, it's commissions, although that can be a little bit misleading as well, because, you know, it's pretty hard for most salespeople, unless they're truly kind of like the old Fuller Brush, you know, or Avon salesperson or something, where they're truly selling independently, that they're not performing an integral part of a, you know, a company that's products they're selling. How long the services are being performed, that's a critical factor, because the more dependent you are as a worker on a particular company, the less likely it really, you know, passes the straight face test for this being, you know, a free agent who's working for a bunch of different people. Now, it's not always the death knell. There are occasions where, you know, like a 1 week project turned into 6 months, and it was, you know, no fault or you know, choice of any of the parties. That just meant like work escalated, and that could be justifiable, because it means that the worker had to sacrifice and put on hold a bunch of other projects. Again, those would be the types of things that you would want to have in the defense file if the hiring companies, because they want to make sure that, you know, a good, you know, company that's hiring someone who wants to maintain justifiable basis for independent contractor classification, they'll do updates. They'll look at these engagements and say, wait a minute, you know, how many independent contractors have been performing work for more than a month? We better look into that. Or, you know, they'll do updates on the insurances that are provided, you know, because sometimes you'll get, you know, a defense file off the bat when you sign someone to be an independent contractor, or vice versa. And, you know, the insurance expire in a month later. The articles of incorporation or maintaining registration with the state isn't updated. So that just highlights, you know, the need to really keep close ties on independent contractor engagements, which a lot of companies just don't do, because they're looking at it more of like, oh, this is just someone, you know, really, we don't want to bring on as an employee. They don't want to be brought on as an employee because it's more of a part-time gig. And that's not going to get you there. The degree of permanence of the working relationship, another factor, it kind of dovetails into what I just spoke about. The longer the engagement, the worse that would be for justifying IC classification. I mentioned the payment method, whether it's by time or by the job. As you can see, it kind of, some of these various separate factors kind of mold into each other. And finally, whether the parties believe they are creating an employer or employee relationship. So actually the intent of the parties in theory does matter, but in practice, very rarely, because, you know, think about it. If a company or hiring company has done just the bare minimum, they're going to have an agreement that they have the independent contractor or the worker who they want to classify as independent contractor sign. And it's going to say independent contractor at every possible place. And it's going to say you're not an employee. We are not establishing an employer-employee relationship. So it'll have those bells and whistles. But, you know, the reality of it is that the courts have looked at that and said, well, yeah, I see that. But I mean, that would be like saying just because the contract that, you know, I have with my employees says they're at will, that I can just fire them for any reason or no reason at all, and I'm good. Well, that would ignore the entire body of discrimination laws, right? I mean, believe it or not, people still, you know, some employers still try to make that argument. They're like, well, wait a minute, you know, I could have fired this person without cause. And, you know, even though I didn't say that, but I can now. And, you know, that should be a defense to this discrimination claim. I mean, believe it or not, some people will still try to argue those sorts of things, but the courts, they don't really buy and put too much weight on that. So what the, you know, worker and the hiring party think of, you know, they're establishing is relevant, but not of great import. So the reality is, what you'll see is, you see why probably in practice, you know, the legislature, Lorena Gonzalez was the biggest proponent, she was the legislature down in San Diego, was able to sway, you know, a lot of other legislatures to say, like, look, we need this simple test. this is getting out of control. I mean, I just read to you, 11 factors. And the courts grapple with that every day. And they have other secondary indicia they look at as well. None of which really leads to a lot of comfort level in decisions that you're making or certainty when the stakes are so high. So it shows you why there was this draw for the ABC test. It also, is not just unique to California. This is a good segue into, what do I see and sort of in my ability to pontificate or prognosticate about the future. And please don't quote me on these things, but I kind of said this stuff back in January, and that is, more states are leaning towards some variation of the ABC test than not. And, I have a chart listing all the states, but 35 plus states have some variation of the ABC test. And I say variation because some of the states have made it a lot easier. I mean, completely easier. So I say, focusing on 3 factors, that's pretty cool in concept to some level of planning, right? Well, they said that B factor, that Massachusetts has and California has, gosh, it seems really stringent and it doesn't really equate to the real world. Why should there not be the opportunity for, more workers to be, viable independent contractors? So we're going to use the, ABC test light is what they say. And we'll say in the B factor, instead of just giving the choice that you have to prove that the work is outside the, the ordinary course of the hiring party's business, they're going to say, or the worker doesn't perform work at any location of the hiring party. So it actually goes to the idea, I mean, really, like, oh my gosh, like that's great because it gives remote workers the opportunity to meet, A and C of the test and make those the real critical facts. Because if you're a remote worker under some of those states' tests that I just said, the ABC test, you can meet B. The hiring party can meet B because they say, look, this worker has never come onto the premises of any of our physical office locations or work sites. They perform all their work remotely. Again, they're using all their own computer, cell phone, etc. So we meet B. And in some of the states, that is an acceptable way to meet B. But we don't have that in California. All of us here in this room are dealing with California. Some of you may be considering moving out of California. I don't know. I've had clients who, and workers who've thought about that and are still thinking about it and thinking about, well, wait a minute, what about if I, set up operations in Nevada, where they have more employer-friendly laws, or Texas, where they have perhaps the most, employee-friendly laws, business-friendly laws. So Texas, Nevada, you pick a couple other states, you can probably guess where they're located. Arizona. But the reality is under California's AB5 test, it looks at where the worker primarily resides or performs the work. So you're still limiting yourself if you're working outside the state to, basically not work for companies based in the state. And it's and most of the time when people go through this sort of exercise internally, they don't usually act on the knee-jerk reaction of, I'm moving out of the state. Or, I heard a lot of people say, oh, I'm moving to Canada. Well, Canada isn't necessarily a solution to this either. They have stringent employment laws as well. I'm not an expert there, but internationally, this independent contractor classification issue is a hotbed item. So you're not going to really avoid it by, relocating your business operations. So you just kind of have to grapple with it and how best to handle that. And what does it mean? The question is, if as you as workers and service providers, are you still receiving any receptiveness from prospective clients to continue allowing you to do work on an independent contractor basis? And if so, I mean, there are ways you can, try to alleviate some of their concerns. I mentioned, the actual independent contractor agreement as being important, but it's really even heightened in importance in this day and age, because you can actually just match the language of the statute to the exception you want to meet. And, for example, that business to business exception, you would actually list all the language in there as sort of a representation and warranty that the parties acknowledge and agree that. And you list them all. Hopefully most of them are truthful, but the more that both parties agree on it, the better there would be an ability to justify that type of arrangement. And obviously the other is just making sure that, you truly do have the makings of a legitimate independent business, because you're not going to see the light of day with any sort of aware hiring party unless you have just the bare minimum of setting yourself up as a corporation or a limited liability company. Ideally have another employee that you W-2. Again, that's the ideal scenario, because in the vetting of what these aware companies are doing, they want to see, and it's not just a one-person business, but more times than not, that's a really hard one. In that sales representative matter I was mentioning, some of those sales representatives hired assistants and set up their own businesses, so they had a much better argument that even though they were working primarily for one company, they at least had the makings and the lookings of a real business. So I thought maybe now would be a good time just to ask a few questions, or open the floor to questions before I go to sort of more of like what I see potentially in the future.
I'll start this off. I've got a couple for you, Dennis. First off, I think would health insurance be kind of a make or break as far as whether someone would be considered an employee or an independent contractor, especially given the current situation?
Did you say insurance?
Health insurance. Health insurance.
Oh, health insurance. In terms of whether you have as your own health insurance or not?
Yeah, or whether the employer provides it, or whether the hiring party, or rather, I should say, whether the hiring party provides it, or whether the potential potential hiree has to provide it on their own.
Yeah. So the answer to that question is health insurance is not one of the things that for example, a potential hiring party really looks at as, because it's actually they're prevented by HIPAA laws from asking about it. But if the hiring company says, oh, we'll give you, we'll put you on your health care plan. Well, great for you, bad for them, because that is a no-no. That's exactly the sort of things like it walks like a duck, it quacks like a duck, it looks like a duck, it is a duck. Well, you're an employee because they're treating you like an employee. I mean, it'd be great, putting the hat on of an independent contractor. I mean, you're going to want to, accept whatever the heck they want to give you, because, it's their, real risk. Is there a risk for, the service provider of an audit and, you being responsible for some element of unfunded payroll taxes? Yes, but knock on wood, I haven't seen that in anybody clients come across my desk, because you're all paying, PIT or self-employment taxes. So there's far less of an incentive for auditors, the EDD or the IRS, to go after that, that element of the equation, the worker element for back taxes. They want the deep pockets, thank God for, as workers. But the downside is, the more that these companies are aware, the less flexibility there is, to sort of be able to provide work.
Fair enough. That's fascinating, honestly. My other question actually relates. Let's have you go first, Monique. I know you had a couple.
Good. Dennis, you answered part of this question, I believe, because you were talking about don't just move your business to Idaho and say that it doesn't apply. So we keep saying California. Do you mean the worker or the worker's company? I have my own corporation, or the hiring company. I'm really not clear on what it matters, whether all three have to be in California, or whether California law this applies, whether any one of those three things are California.
Yeah, well, that's a great example, Monique. So let's assume that your company is registered in Idaho. If you live in Idaho as well and you're performing work remotely, there's a very good argument that Idaho law should apply only. And so let's say a California company wants to hire you to write an article for them, a piece or something, then there's an argument that the ABC test under California law should not apply, because you're looking at essentially, the workers protecting the worker from essentially being victimized. But let's say, and the company would have no reason to file a lawsuit against you in California, but let's say,
I'm actually more interested in the opposite. I'm in California. I'm not going to move my business from California. Will hiring companies outside of California not want to hire me because they have to meet the California test?
Yeah, in short, yes. Because it looks at primarily, just to answer, because I was getting a little complicated in my answer, but yes, the hiring company that's doing this vetting of determining whether to, hire someone as an IC or an employee, they're going to look at, obviously, if the company's in California, then they got to deal with AB5. But they're going to be looking at where you primarily are going to be performing the work or residing. And if you reside in California, they have to realize and are going to be worried about AB5.
Even though the company itself is elsewhere. Okay,
that's correct.
Thank you for clarifying that.
And the reason why is just, and they could even include in the contract and you agree to it, that Idaho law should apply. But if you, this is where the company would have to take on this risk. If you filed suit in California, they would have to answer that lawsuit in California, and a California court, regardless of what that contract said about the law, goes to a balancing of interest between Idaho's public policy and interest in independent contractor classification in California. And since you're in California, you would say, look, I should be entitled to California law because we have this incredibly employee-friendly, law that's just etched in stone, and there's a presumption of employment. And most likely, regardless of that, we call it choice of law, the California court would say, yes, California law should apply, even though it's an Idaho company that hired you.
Okay. I have a follow-up, but I will ask that after everybody else gets a turn, if we have time.
Okay, Bruce, I think you're about to speak up.
Yeah, about 90% of the jobs I do are through the company. They're usually big companies, and they deal with this whole issue by having an agency act like a beard. And the agency, I'm a W-2 to the agency. The agency does absolutely nothing other than find me and find the client. And is that going to continue under all this, to be a way around this, or is that going to be affected by any of this new legislation?
Well, it's going to continue. It's called employer of record, because there's kind of like lowest hanging fruit as the theory for both plaintiff attorneys seeking to sue for misclassification, as well as auditors for state agencies. So I mentioned, my clients do sort of more than just, they're the face. They do a little bit more than that. But in theory, yes. I mean, that's called an employer of record because the agencies are wanting to make sure there's payroll taxes paid and that, the bare minimum of employment benefits are provided. And so that's where they're looking. Now, there's certainly cases called joint employment. There's plenty of cases that are out there where, essentially, let's assume that you felt you were being treated unfairly. You weren't paid your full wages. If you're, paid for, by the hour, you were told to work off the clock or something like that. You would bring suit against both, your employer of record, the agency, as well as the company, where you're primarily performing the services. And then they'd have to fight it out about who's more liable than the other, because both likely would be in the mix.
I have a question.
Yes, Joe.
In the Borello test, you mentioned the contractor should be using his or her own equipment.
When these cases come up, when there's actual, the state comes in and files a case or something.
Bruce, I was talking.
Sorry?
Joe is asking a question right now. Could you hold on?
Oh, I didn't hear that. I didn't hear anybody say anything. Sorry.
Hold on for a moment.
Yeah, the Borello test includes whose equipment is being used, the hiring company, the client, or the independent contractor. Now, in the kind of work I do, for reasons of data security and just being able to get the work done, I usually have to use the company's laptop and the company's VPN and probably their software, because there would not be a way to integrate my computer into their network without all sorts of data issues or security issues. How big of a problem is that?
It's not a good fact, but if you have, I mean, if that was the only, or, you know, one of the only sort of bad indicia of independent contractor engagement, I mean, I think that would be one that a court could look past, because, you know, you still have your own equipment, like your business. You have your own, you know, I'm assuming you're sitting in your office. In all other circumstances for other clients, except these, you know, really data sensitive projects and matters, you utilize your own computer, you utilize your own cell phone. In this engagement, the only thing of theirs you're utilizing are those designed and needed to protect data sensitive issues. I think that would be justifiable. Again, you would, you know, you wouldn't want this to be like this long-term engagement, because, you know, the auditors would look at this and a court would look at it and say, okay, well, let me see the other factors, right? Like that, you know, that's okay. It could go either way, and there's a justification for it. I mean, you know, it's really the hiring company. Ideally, they find a way where they can come up with, you know, firewalling off, you know, whatever your use is, whatever your access is to their information, by you can just use your own, you know, cloud-based access or something. But I don't see it as the death knell in itself.
Okay, good to know. Thank you.
And then let's go back to Bruce. Bruce, you had another question that you were about to ask?
When a case comes up and the state's, who initiates it? I mean, if the client is happy and the customer is happy,
Yeah.
Does that sort of like keep it from bad stuff from happening, or does the state sometimes just decide, oh, no, this isn't right, we don't care, everybody likes it?
Both. But for this audience, and what Joe had told me, I've been focusing more on the concept of, you know, workers who like the benefits of being IC. But remember, you know, bad facts make bad law, depending on your determination. It's Borello, and it's spelled Borello, and it's a California Supreme Court case. And that was brought by the workers. And most cases are brought by, you know, the attorneys representing the workers. Now, you know, of course, with AB5, you probably saw the Uber Lyft case. There's a preliminary injunction forcing them to be classify their drivers as independent contractors. That was brought by the state of California here in, you know, San Francisco Superior Court. So what I tell my clients, and let me just pretend I'm talking to my clients, you know, no names given. They say, hey, you know, we have this independent contractor agreement. It was prepared by a top-notch law firm. And, you know, we just got this claim from EDD for this worker, you know, that was an independent contractor, and it's for unemployment. You know, I mean, this worker, you know, totally wanted us to be retaining as an independent contractor. I know they wrote off so much stuff because they were telling me about, you know, how they were able to get money back in their taxes. You know, we got to throw the book at them. You know, you need to go tell the EDD when we appeal this decision that they're just so wrong, because, you know, this is not what the law was intended to cover. And I'm saying, sorry. I mean, all it takes is one disgruntled worker, and you know, that worker could be all, you know, all for the benefits of being an independent contractor until they're not. And, you know, that could happen like that, because, you know, everything's happening great. And then, you know, let's say, you know, COVID happened, and like, sorry, I don't have more work for you. And then they go to the EDD, file a claim for unemployment, and like, oh, well, that's not fair. It's not, but that's the risk you take.
All right, I do see a couple of raised hands. I'll go Sarah first, and then Andrew, and then we'll go back to you, Monique.
Thanks. if I just want to do a one-off project for another company, it's not like I work full-time as an independent contractor, do I need to worry about making an LLC or any of this other stuff?
Well, I will tell you, if the company that wants to hire you doesn't care, then and it doesn't make economic sense for you to do that, then the risk is on them, not you. As long as this is, like, from your standpoint, it's justifiable. This is a one-off engagement. It's not like you're doing this for one company for a bunch of period of time. So that's my, there's a lot of, people who do things, just side jobs, like, true gig, sort of like, their third job, but they work for two employers. And they don't have the money to set up a company, So those are like those sort of, exceptions to the rule I just mentioned. If there's people out there that'll hire you without doing these things, the real risk is on the hiring party. But I think the vast majority of sort of the questions that are coming up in the arena of the field that you're in is going to be primarily from hiring companies that are worried about the exposure to them.
Thanks.
You're welcome.
All right, Andrew, you had one?
Several, but let's.
There it
I've
is.
watched this space a little longer than you have, since 1706, 1986 tax law, Ronald Reagan's Tax Simplification Act. Do you see a sting in the tail from giving benefits to people who were independent contractors and still file for unemployment during the pandemic? And if so, how are the contractors going to get hurt?
Well, yeah, you're speaking to the expanded benefits that basically the state said, okay, even if you're an independent contractor, you can obtain unemployment insurance, and we won't use that as a red flag for an audit for the company that hired you. Is that what you're speaking of?
That is correct, yes.
Yeah. So yeah, I mean, well, I had clients that said, what do we do? I mean, I said, well, what do you do is, in responding to the claim, you say, if it's true, we've never retained this worker as an employee. This worker performed work on an as-needed, intermittent, sporadic basis as an independent contractor under an independent contractor agreement. So you have that response, in writing to the EDD as the company's position. The EDD has said, like, oh, we're not going to use this as a red flag for audits. No, I don't believe that. It's kind of like the IRS used to say that, there's a form called an SS8. It's a question, essentially a worker or a company can write to the IRS and fill out this information and say, here's all the things that this worker is doing. Do you think they should be classified as an employee or an independent contractor? Well, and it was designed to be, we'll just give you a kind of a non-binding information determination. Well, that has been confirmed to be used as a red flag for an audit. And I've had clients, whose workers did that because they were trying to set up the company, the employer, for a lawsuit, because an audit will start that. And then the employer found out they did this, and they, before calling me, they fired the guy. Because they're like, oh my God, he's trying to destroy my company. We have a viable basis for, retaining all these independent contractors. So it was just a mess. But yeah, I think, it's going to be a real, another hotbed of audits and potential litigation, Andrew.
That's what I feared. It seemed like another exploit from the government. Say, we want yet more payroll taxes, and we will say about it.
Yeah.
And net contractors, really, if they don't have income, have no choice. I mean, it looks like free money.
Exactly. Yeah.
Yeah.
And they couldn't. The other aspect of it is they were telling me, like, oh, can I tell them not to file? Like, it's going to destroy my company. I said, last thing you want to do is be like accused of interfering with the process. You're going to piss them off anyway. Instead, the best thing you can do is just be truthful in your statement and have that statement that, you would use to defend, hopefully, what was a at least a good faith basis for how you classified them in the first place.
One quick follow-up to that. As a recruiter, I end up counseling clients, that corporate clients, about this a lot. And many of them are far less sophisticated and informed than you are, and even than I am. They wave their hands away and says, not an issue, it's just a tech writer. And I wag my finger at them and say, yeah, but it's going to be the thin end of the wedge. One audit will get all your contractors and you will rue the day. And they ignore me. Is there something else I can point to other than huge decisions like, I don't know, Microsoft? Or what would you do for me?
Yeah, well, I deal with that all the time. So what I actually do oftentimes, because I'm faced the same sort of issues as you face, you can only tell people the same thing and try to use scare tactics. But I try to tell them, okay, let's just use a really simple example. Let's say, this one worker sued you for, unpaid overtime because they're claiming that they were misclassified. They shouldn't have been an employee. They were working 15 hours a day. You paid them $200 a day. Think about the effective overtime rate. You work for 7 months. All right, that's just a one employee lawsuit. If you pay my firm to defend your company in that case, and you lose, you're going to pay my firm probably, $200,000 in attorney's fees to go through trial. Remember, very few cases ever go to trial. But listen, if it happens, $200,000, easy. And that's going to be maybe, luckily 18 months from now. And if that employee, wins that one claim, just say they misclass, the court says, yeah, this should have been an employment classification thing. And let's assume that they didn't really hit a home run on the court's like, oh, come on, who works 17 hours a day? You're working more like maybe 9 or 10. So they'll split the baby, and let's say the result is, $50,000. Well, you're out $200,000 to me. You're out $50,000 to the employee. And because there's a prevailing party, one way only employees attorney's fees clause under the statutes of California, you have to pay that guy's or that woman's law firm all of their attorney's fees. And then, so let's add it all up, and I'll show you my litigation budget so you see the steps it has to handle for my fees. They're going to say at least the fees are as much as mine or more. So you're talking about what, $450,000 to $500,000 for one worker for 1 year.
Thank you.
And that usually gets their attention.
Indeed, I can guarantee it would. Thank you.
You're welcome.
Back to you in a second, Andrew, if you got any more. I would go back to Monique. She's been waiting patiently here for quite a while.
That's good. In fact, Bruce started the conversation with my question, which
Any
was,
other questions, Rachel?
I do. We're going to Monique for this one. Monique.
I'm over here. Well, it's hard to know on the Zoom screen because they move around. So, Dennis, can you hear me?
Oh, are you able to hear her, Dennis? Or
Hello? I was starting to talk about.
Sorry, my internet connection is unstable. Are you hearing me still?
we can hear you.
Yes, we can hear you.
Okay, I
We
just
can hear-
cut
we
out
can-
a
we can
little
hear
bit,
Monique
Rachel,
too.
in that last bit.
Gotcha. No, so go again, Monique.
Okay. Bruce started the question that I had, which was who files the suit?
Oh,
And you
yeah.
talked about perhaps a disgruntled employee, well, not employee, but a misclassified person. And
There you
that
go.
really was what I wanted to know, because from time to time in my consultancy, I've had clients that end up quite a long time. And sometimes I have multiple clients. Other times I do end up in one client situations for a good long time. And I've been worried about that when that's happened. But if I have no intention of bringing a suit because I'm the one who doesn't want to be the employee, and the company, of course, is not going to, are there any other parties that could have an interest and know about it and bring this suit? Because you mentioned part of the reason, of course, is the state wants its payroll taxes.
Yes.
How would what kind of flag would there ever be for them to look at?
So I had this in another case recently. supposedly it did not come from any of the workers, and there were 6 workers in a public relations company. And the EDD audited the company, and the triggers, supposedly they said, was that the officer had only reported wages of like $20,000 to herself, and but actually there's a K1 of $300,000, and it was a consistent, sort of scenario. So that just resulted in the EDD coming in and saying, this doesn't sound right. And by the way, wait a minute, where are these W-2s for these other people? So none of the workers complain. So there's all kinds of, and that's why in your scenario, a good company, like a real best practices hiring company, would be looking at, okay, what are the lengths of our contractor engagements here? And then they might see Monique and say, this is too long, because it's a risk for us. But hopefully, for you, that doesn't happen.
But that was interesting. You mentioned the workers' wages compared to the K1, because in fact, my accountant and my attorney have made sure that I do pay myself. I don't pay myself a high salary, but I pay myself a real enough salary compared to what I take as my K1 shareholder.
That's great, because I'm learning more than I ever wanted to know about reasonable compensation to officers, and all the penalties associated with it. So I have an appeal that's now going to go to the Unemployment Insurance Appeals Board, and I just dealt with the administrative law judge today. And I was like, oh my God, thank God I don't do this all the time as part of my practice. It's just,
but there aren't really a lot of, it's not like there's this world of 50 triggers that might cause this. There are very few in number that it kind of sounds like almost collateral, like they were audited for some other reason and happened to see it.
Yeah, I want to say, but there's, I could come up with a bullet point list of, the types of triggers that end up being more than just, a few. I mean, so workers' compensation, another trigger, an employee who's, let's say, well, it's hard with remote work, but I could come up with an example. But oftentimes it's going to be, Andrew Davis's world or mine, where there's going to be, or Bruce, let's say, you have a scenario where hiring company has Dennis go off-site because there's an audit, a tax audit. I'm looking into reasonable compensation of officers. Oh, and I get hurt on site at this other place. I tripped and fell down the office stairs. I go to the doctor. One of the things you probably have filled out in your world, if you ever got injured, they'll say, was this, where does this occur? Was this connected to work you perform? Because they want to find out if it falls into the workers' comp world. And you have to be truthful about that scenario. That can result in, a claim for workers' compensation, unpaid benefits that had, nothing whatsoever to do with, whether someone's an independent contractor or not, but ultimately does. And that kind of that type of action, which is brought by the agency that handles underfunded workers' compensation accounts, they have memorandums of understanding with the EDD and the IRS, so they can be essentially information sharing.
Okay, thank you very much.
Do we have any more questions? I know I've gotten one, but I'm going to wait till the end with mine. It's not exactly that relevant, I don't think. Well, it might be. Does anyone else want to go before me? Anybody else? Andrew, go for it.
Thank you. So one more question related to my nemesis. And as I do business with larger companies, only occasionally, I run into managed services providers. These are umbrella organizations like, they're just general purpose IT recruiting firms. And they seem to be very fond of forced furloughs. Like, you can work for us for 12 months and then you have, or our client, and then you have to go away for 3 months or 6 months, and then you can come back. Is there any legitimate reason for an IRS or EDD sites for doing that, or is that just a relic of old tax law?
I think it's more the latter rather than the former. I've written and spoken about this whole 10-year limit thing,
Okay.
which is, you know, kind of what you're referring to in different labels. But I mean, ultimately, the concept is the longer the engagement, the more, you know, risk there is that, you know, you're not going to meet all the factors relevant to viable independent contractor engagement. But that in itself is not, you know, the death knell. More times than not, what you've just described will actually be used in the scenario where, you know, it's the staffing company serving as the employer of record, and they still say, you know, oh, this employee's been working with us too long. Like, well, no, that's stupid. That's silly. The bottom line is, you know, is there a viable employment engagement and someone getting a W-2? If so, you know, the fact that you have, you know, this tangential, you know, employee that they don't want to have, you know, directly employed shouldn't be a reason to stop that, you know, element of staffing.
So these are contractors working on W-2 in almost every single case. It's almost impossible to work either corp to corp or 1099 through a managed services provider.
Yep.
So how does a contractor speak truth to power and say, forget this forced furlough or your term for it, you know, don't send me home after 12 months or 18 months. You're just going to have to try to replace me. It's going to take 3 months. You'll never find somebody who knows what I know. Shape up. Is there a way, or have you found a way to halt that practice? Because really there is no liability to the ultimate beneficiary of those services.
Yeah, I've just kind of said, well, tell me what I've always turned the tables on it, but let me just, so I'll say, hey, listen, you know, can we both agree that, you know, I am an employee of a viable agency that's providing me benefits and insurance and that's complying with the law. As long as you know, aren't telling me to do something that's not in compliance with the law, we're all good to go. The fact that, you know, you don't want to make me a direct employee and I don't want to be a direct employee, you know, has no bearing whatsoever on whether you can continue this engagement. I mean, this is a relic, this concept that you can't have, you know, someone like me work for, you know, longer than 12 months and have a break in service. It has no basis in any legal risk scenario. And if you have something to tell me that is a basis, I'm happy to look at it. But and so to your point, you know, the only thing that makes sense, and I tell, you know, the companies that are worried about this, you know, where the places where the workers who's being contracted is, you know, staffed out, like, well, listen, the only thing that you should be thinking about is if you have someone for 12 months, you know, that may be an indicator. Maybe that's someone you want to bring on full time, and they might want to be, because if they could get stock options or a robust healthcare insurance plan or the like, you know, that's usually the scenario, is the company's using the employer of record option because they don't want to have to pay these robust benefits and higher comp as they do their direct employees. And so, yeah, I think the way to do it is to just highlight, you know, listen, I'm a valuable commodity. There's not a lot of talent out there like me. And, you know, there's no reason that you need to break in service to do this, because it's not a legal risk. And if you have something to show me that is, I'd be happy to look at it.
Great. That's really helpful. Thank you.
That happened to me with Adobe, where I worked for 18 months through an employer of record, and at the end of 18 months they said, sorry, you've reached our limit, and goodbye.
Yeah. Unfortunately, it doesn't matter how big or how small, but, you know, how well funded or long, you know, lasting the companies are. More times than not, they'll just have these creatures, as you say, Andrew, of years of just legacy practices.
Most every company has idiots on board.
Correct.
Nikki, you had a question real quick.
Yes, I do, because to that point, I was working as a tech writer for an employer in Silicon Valley until recently, and one member of our team was someone who was a independent contractor. And she actually did take a furlough, a 6-month furlough every 2 years. And, she says, well, I have to do this. She did have other clients, you know what I mean? But she told me, yeah, I have to take a furlough every 2 years so that I don't get mistaken for an employee, even though I believe she was a 1099 contractor. So I'd just like to know if you could comment on that.
Sure. Well, yeah, Nikki, that's a great, because that is the issue where, longevity does matter, is if, someone is being classified as independent contractor, because it goes back to all these factors. I mean, it sounds to me like that person has no business being classified as independent contractor.
Well, she started as an employee in, I think, 1990 or something.
Yeah. Well, that's even worse, usually, because if they used to do the same job or a similar job as an employee, and then they just, and this happens a lot, believe me, and then they just, well, I'm not going to be working as much, or I want to just, slow down a little bit. And they say, okay, well, then we'll just bring you on as a consultant, and they 1099. Well, auditors would just, salivate to have that, because, you were previously working as an employee receiving a W-2 by the company. You're performing the same or similar services now, but as a 1099. What viable basis do you have, company, for doing this? And they're like, well, she asked for it, or he asked for it, and he's sort of, wanted to slow down and maybe do other side jobs. Like, okay, well, that's a part-time employee. Yep. That's how that works.
Yeah, I think she did. She did have other clients, and she'd come in and she'd work maybe 2 or 3 days a week at her main employer, and then she'd see other clients in the meantime. So anyway, yeah, I mean, it wasn't like she was working full time during 2 years. Yeah, she'd be on and off and on and off, and they'd bring her in for, to do sort of emergency things, when they had a time crunch or something. Yeah.
Yeah, I mean, if I was the hiring company, there'd be no way I'd do anything but W-2 her and just have her, retained as a part-time, as needed, sporadic.
The names have been changed to protect the innocent. Okay?
Yes, exactly.
Not to mention the guilty.
Yeah, the innocent don't need protection.
I might not have, my perception of it might not be completely accurate, because it comes from what she told me. Well, I have to sort of do some work off, for another client, so I can be she wanted to be an independent contractor. Okay.
Remember, your testimony is being recorded here.
It technically is. This is still recording right now. I'm recording all the questions as well.
Oh my God.
No, you're fine, Nikki. You're fine. Are there any
No names were mentioned.
No names were mentioned. Yeah. Thank you.
Are there any other questions? I think I have one more, but I'm going to wait. Or I guess I'll just go now then. And more just a curiosity, Dennis. I don't know how aware you are of international law. I'm guessing probably at least somewhat, if not more. But do you know of any similar laws or similar multi-factor tests that are at play in the rest of the world, or do they handle things differently?
I know just enough to be dangerous. I've gone to a few conferences where they have international speakers, and one of my clients did do international law. The answer is yes, they have similar laws. I did actually have, I just remembered now, I had a US-based employee who was going to be hired by a German-based company. And yeah, so they have very similar situations where workers are protected as independent contractors. There's one, company called CXC, I think it is, and they handle kind of international independent contractor compliance. It's a hotbed. So yeah, everybody else is dealing with very similar things, although they may be a step ahead. I mean, Canada, for example, has a third category of worker called a dependent contractor, which is a whole nother topic, but the concept is sort of akin to where Uber and Lyft are trying to go, just for their little businesses that, not little, but, where you would have, you have kind of you have a worker's got one foot in the employment box and one foot in the independent contractor box. They can still, work non-exclusively. They can write off a lot of expenses. But yet they would get, some level of minimum benefits, like for healthcare. they would get some level of payroll tax funding for unemployment, as an example.
That's still really interesting. Thank you so much, Dennis. All
I do
right.
have,
Oh,
could I ask one more? So in this wonderful pandemic world, a lot of my clients are saying, okay, we can't afford Bay Area talent. Bring us remote talent from outside the border. And I'd like to know whether my clients are about to make a big mistake or whether they've discovered something that is going to make them even wealthier at the expense of contractors here by going to Ireland, by going to Eastern Europe, by going to South Africa, by going to Israel, where anybody can't blow the whistle on them and say, oh, I was an employee, because tax laws are different.
The answer to that question, Andrew, is I know just enough to be dangerous, but that's when I call my immigration attorney colleague, because it raises immigration issues. And I don't know the answer to those, but I do know from the standpoint of that one situation where, you know, you have to look at both the laws still domestically if, you know, because the company's based in California, for example, as
Sure.
well as internationally. And I don't know precisely about Ireland, but, you know, Germany, I do know a bit about, because that was that one scenario, in England. And, you know, the European countries are likely not better or more favorable for business than California.
If they don't have a legal presence in the country where they're hiring the quote contractor unquote, are they winning, or are they about to get hurt more by a contractor raising their hand and say, I should have received benefits?
I think that they're potentially facing bigger exposure because they have to worry about both the domestic and, God forbid, the international, because, you know, if the company is not registered in, you know, Ireland or whatever, and there's some legal proceedings brought, it's a mess. I do remember that being a takeaway from my German experience.
Okay. All right, well, I will scare them back to the US so that they hire locally.
Yeah, at least it's a devil you know.
Thank you.
That's interesting. All right. I think if we, do we have any more questions at all? I think we are running a little bit over time, but frankly, that's fine. This is getting really interesting. I'll be quite honest.
Well, I smell garlic cooking and olive oil, so I think it's time for me to go.
Yeah.
Well, I will say
Thank you very much for your time.
Yes, thank you. It's very good.
Speaker Denis Kenny, everyone.
Hey, thank you. It was a pleasure. And if you need to, you know, talk offline or, you know, send me an email and, you know, think about me for any referrals.
Will do. I'll go and stop the recording now then.